All right, good morning, everybody who's just starting to join. I feel like I say this a lot, but just give us a minute or two. We're going to let the attendees filter in before we get started. So just bear with us. We'll just be a minute or so. All right, we're going to give it one more minute before we get started. One more minute before we start, and then my dogs decide that that's the time to bark.
That's it.
All right, so let's get going. It is Wednesday morning, and today we have John Murdoch with us, and we're going to be presenting on critical legal issues for selling your business. This is part of a three-part webinar series, but don't worry if you haven't seen the last two, or if you haven't attended the last two, you can always find them on our YouTube channel, which is Monmouth Score, YouTube, and just search for Monmouth Score. As I said, presenting is John Murdoch from Zager Fuchs. He is going to take over in a second, but I'll just give you a little bit of housekeeping. We welcome questions. We like them. We like the interaction. We like to engage with you. But what we would like to do is ask you to post them in the Q&A function and not in the chat function, because it's just easier for us to measure that. And make sure we get to all the questions. This webinar will be recorded and will be on YouTube as well. So just bear with us for a couple of days after the webinar, and we'll get that posted on YouTube. Monmouth Score, we are a national entity, but we are part of the Monmouth chapter. We are all volunteers here. We help mentoring for small businesses. If anybody you know needs a business mentor or is looking for someone just to help them in with their small business, the services are absolutely free. And likewise, if you ever know anybody who would like to volunteer, or you yourselves would like to volunteer, we're always looking for volunteers as well. I think that's my speech. So John, I'm going to hand over to you.
All right, great. I'm just going to take a moment and click on the share screen function. And just let me know if you can see everything. All right, is that, can you see the screen yet?
Yep, we can see the screen.
Oh, fantastic. All right. Well, good morning, everybody. And thank you so much for joining me today for this presentation. It's an incredible honor. And I say that all the time, and I really mean it. I really enjoy doing these presentations because I feel like I get an opportunity to maybe connect with individuals who might need additional information before they consider engaging in certain type of legal activity, in this case, in potentially selling a small business. I'm a corporate attorney and a healthcare attorney. I've been practicing for about 22 years, and I've done a lot of transactions for small businesses, whether setting them up, assisting clients with purchasing, with selling their small business, leases, franchise agreements, etc. I also do a lot of work with healthcare providers with the same issues, and also regulatory compliance. So again, my goal here today is to provide an overview of selected critical legal issues. Not that you're going to walk away with any type of checklist that you would use in considering and selling your business, but I want you to walk away with key concepts for you to understand, because then you can always look for additional information. You can get additional information from your trusted advisors. So again, that's the real concept, is to give you that flavor, that an overview of what's going on and what you should be thinking about if you're going to sell your small business. As Claire mentioned, this is part of a three-part series, and one of the presentations was on starting a business, one is purchasing a business, and this is selling business. A lot of the concepts are similar, but I do recommend you watch those videos as well. All right, some just introductory remarks. The presentation doesn't address any business issues. We're not going to get into business plans, chances of success. We're not going to get into issues if there's multiple owners and some subtleties. Again, these are just general critical concepts, but selected critical concepts. And again, not business or really tax issues. And due to the limited amount of time, we won't be able to go into any of these topics in any great depth. Again, we're looking for the flavor, the feel of what's being considered in selling a business. And the information is presented for discussion purposes only and cannot be considered legal advice. You really have to consult with competent legal counsel and really present the specific facts for your business. So selected steps in selling a business. And I use the word steps just, again, it's arbitrary, but it's a way to think about the legal process in selling your business. So we're going to talk about identifying potential buyers, negotiations, due diligence, purchase price, valuation, financing. Again, more from the legal aspect, not so much from the business. Letter of intent, purchase agreement or sale agreement. We'll talk about closing and then maybe some post-closing considerations. Again, and these steps are not necessarily the perfect order in what would happen in selling a business. They're largely in the order that these events would occur, but some things could change. Some of these steps could be fluid and actually appearing earlier or later. So first, identifying potential buyers. So there's various methods for identifying potential buyers. You may be dealing with a broker. You may be contacting a buyer directly. You may be working, you have a franchise and you're working with the franchisor. There may be advertising. There may be a bunch of other ways that you may be identifying a potential buyer. The key issue to consider is from the seller side, you're always concerned with the amount of information that's going to get out before you want it out. So when you're thinking about how you're going to identify a potential buyer, you have concerns about who's going to find out that you're thinking about selling your business. There's certain people you don't want to know. Your employees, you're not going to want them to know. You don't want them leaving, thinking that they're going to potentially lose their job. You may not want your landlord to know. You may not want, customers or referral sources to know. So you always have to be very, very careful in what you divulge. And we'll talk about this a little bit more as we talk about due diligence. So we get into the negotiations. So first is, what is a contract? I bring this up because a contract doesn't have to be in writing to be enforceable. There are some exceptions. There's a statute of frauds. Certain types of contracts are so important. They have to be in some type of writing to be enforceable. One example will be real estate, but that writing could be several different forms. It could be maybe an email and a check. So you just have to be, you have to be very careful that when you're starting to negotiate for the potential sale of your business, that you don't accidentally wind up being in a contract where now you have problems if you want to change the terms a little bit later, or maybe the terms weren't exactly what you understood. So you just have to be very, very careful what you agree to. A great way to approach this is whenever you're discussing with anyone, a prospective purchaser as well, we always have to have our attorney review before we give our final approval. So you just have to be careful with that. It's not typically an issue, but I have seen it come up where it's the purchaser is insisting that there's a contract because of emails that have gone back and forth and from other things that have occurred, and they're trying to squeeze the seller into giving the purchaser the deal that they want. And again, it's something in one of the cases, it wasn't a fully negotiated set of terms for the agreement. So again, you just have to be very careful with that.
John, is that something that could be construed though? If somebody had an email that said, I want to buy your business for, for $57, and you email back and say, yeah, that sounds like a really great idea. I think you can. could that be taken? Could that be used and potentially, even though it's not a part of the contract, could that be, you know, interpreted as a meaning?
Yeah, and that's a great question. So, just briefly for contracts, you need basically an agreement of the terms, mutual agreement between the parties, and then typically consideration. I would say there's a good argument in that scenario that there really isn't a binding contract. However, you may have a buyer say, wait a second, we have a deal. You told me you'd sell for $57. Now you have to be reasonable in the terms of the contract. You can't start coming up, seller, with unreasonable terms, or unreasonable to the buyer. So again, you just have to be careful. And something like that, I would say, would be very difficult to enforce. The more complex things become, the more of a chance that someone is going to try to use that. Prospective purchaser may try to use that to try to force concessions from a seller. So that's really the key point. But typically for a contract, you need an agreement as to terms, and then you have to have some type of consideration, usually with some money. And that's what happens a lot of these times. There may be a deposit paid, and then maybe that agreement. So back to that scenario, someone says yes, and the seller says, all right, well, send me $50 deposit. All right, now it's starting to look like a contract. So that's where you just have to be careful.
Okay, thank you.
Oh, my pleasure. So need for confidentiality. Buyers are typically not so much concerned with this. There's exceptions, but the seller is very concerned. I mentioned it briefly before. So as you start considering sharing more and more information, you want to think about, how do I try to protect this information so it's not something that's disclosed everywhere, and now it's out of your control. So typically in the negotiation process, a lot of times there'll be a letter of intent. We'll talk a little bit about that. There may just be a confidentiality agreement. There may be some other type of agreement. But a big consideration is you disclose as a seller only as much as needed to get you to the point where you want to be. You hold back as much as possible without losing the deal. But when I say that, you may disclose a lot of information and you still may lose a deal. And now that prospective purchaser has that information. Depends on your type of business. There are, again, it's very nuanced depending upon the types of business. But let's say you're a software developer. Maybe disclosing your actual customers, your clients, may be something you don't do until the very end of the closing. You don't give that up as part of the initial negotiations. You may describe who these customers are. You may not really go into a lot of detail about how your business is performed. But at a certain point, a buyer may say, well, I don't have enough. I'm not having a good feeling about this. I'm going to walk away. So as I put down there, negotiations are a dance. And you have to be very, very careful, keeping the buyer interested, but also not giving away too much. And again, we'll talk more about that. I put in there, be prepared, as buyer will have only limited patience. So being prepared with your documents, your information, and the information you're ready to provide is critical. So when you go to start selling your business, trying to sell your business, you want to make sure you have all the information basically ready to be disclosed when you're ready to disclose it. And if anybody is interested, send me an email and I'll send you out. I have a little worksheet. It's called Get Your House in Order. And it's meant for sellers who are thinking about selling their business, and kind of like a preliminary checklist on items to kind of try to think about cleaning up. So this way your entity is more attractive to a potential purchaser. So put in there, negotiate in good faith. You don't have to disclose everything, as I've mentioned, but you've got to make sure that you're careful not to intentionally mislead, not to do anything that's really would be in bad faith. The goal here is to negotiate in good faith to facilitate the process, and you want to have the goodwill of the buyer. You don't want it to break down and then just have a terrible time of trying to get to closing. And then consider the psychology of the parties. It's very interesting because as I've been practicing, I see that there's definitely two key things I'd like to mention. One is when a seller In this case, I'm talking seller. I'm talking really about the owners for this perspective. The seller, the owners, they made a decision to sell. They're looking to go. They want out. They don't necessarily want to be part of the business. Not always the case, but that's typically the case. And sellers are often more willing to make some negotiations as time goes on, but they become very, very upset by it. A purchaser, they're usually excited, and as they go on, they're now trying to find ways to maybe knock down the price that they can. So they're excited, but they become sometimes a little more wary as they go in through the process.
I can just to say something to that, John. I have sat on both sides of the table, both buying and selling. It is really, really, you talk about the psychology and people don't think about that. It really is something to consider. And you really kind of have to almost keep yourself in check, because selling your baby, which is your business, it's your business, you've built it, you've grown it, you've sold it, and you're selling it. And it's stressful. And in the same on the flip side, when you're buying something and you're excited, and that's also stressful, and it can cause you to perhaps not always make the best comments or statements and heat of the moment, things that can't be taken back. So it's kind of like buying a house, right? It's not dissimilar. So I would always say I'm so glad you put that in there, because it really, nobody thinks about that part of it. And the psychology behind buying and selling a business is really, what is it, like what's that Star Wars statement? The force is real.
That's right.
It's
Exactly.
not, yeah. So I'm glad, anyway, as I said, I'm glad you put that in.
Oh, great comment. And yeah, so the point here is to think about it, and think about there's different goals, which may be obvious, but the different hopes, dreams, and to be very aware and clear, going to what you said, is to be mindful what you say, because you can't take those things back. And I've seen relationships between buyer and seller really break down, where now it just makes everything very, very difficult. And so you want to think about psychology and to preserve the goodwill between the parties. All right, so we go to due diligence. Now, typically with due diligence, you really think about a purchaser. They're looking to buy the business. And again, we're going to go talk about some of the differences between what I mean by buying a business. But the purchaser's goal is to become completely satisfied with the business. They're trying to find out as much information as possible, all the tax, financial information, if there's hard assets, doing inspections, if there's locations, inspecting the premises, finding out about the employees, about the customer base, et cetera, et cetera. So they really want to understand what's going on with the business, and is it viable, and is it what they think it is when they began the process of looking into purchase the business. Now, the seller may also be doing due diligence. Depends on the deal. Now, if a seller is looking to sell, and let's say they're selling for $1 million cash, and the purchase price, is cash at closing, the seller might not be overly interested in doing any due diligence into the buyer. Sometimes they do. And again, each matter is a little bit different. But a big thing with due diligence from a seller's perspective is there going to be any type of earnout? Is there going to be any type of maybe bonuses, commissions paid to the seller, the owners, after the closing? Is the seller vested in the success of the business? In any of those cases and other matters, the seller may be really wanting to make sure that that buyer is the appropriate buyer for the business, and maybe a different buyer is better. So that's where you may get some due diligence actually done by the seller. Seller is going to, let's say, take back a note. They're going to finance a portion or all of the sale. May want to do a credit check of the individual owners of the new business, and maybe to check to see if they have any assets that the loan can be secured. So again, depending upon the circumstances, but a seller may be engaging in due diligence as well as the purchaser. And I put down at the bottom, the buyer, seller, and the owners have some similar, but also different goals. And I guess now is a good time to talk about what I'm kind of referencing as we're going through. You have the buyer and the seller. When we're selling assets of the company, which is probably for small businesses, probably 90%, maybe a little bit higher, is the is what occurs versus buying the equity. So in that case, you think, you have the buyer, you have that's going to buy the assets of the seller, which is the entity, the business entity that's operating, and then you have the owners of that business entity. So that's something to consider as we talk about some of the items in the future slides here. All right, so due diligence, again, maybe more limited for the seller's perspective versus what the buyer may be looking at. But you think about, depending upon what your due diligence is going to be into the buyer, you assemble your team. Do you need an accountant involved? You're taking back a promissory, you're issuing a promissory note to the buyer, let's say for the purchase. Do you need to talk to the accountant about doing credit checks, tax issues, things like that. If you're really concerned about the viability of the business after the closing, do you need to have specialists kind of take a look at the buyer and the buyer's capability? So again, just think about team members that you need for the due diligence. We talked about confidentiality briefly before. Got to make sure that as you're going through the due diligence, that you're going to have some confidentiality provision somewhere, whether it's a letter of intent, whether it's a separate confidentiality agreement. And this becomes, again, critical for the seller in turning over different information. I mentioned before, this is a dance, and figure out how much information will be disclosed now versus later. I'll give you an example. We have some types of transactions where a lot of the information is disclosed right away. Pharmacy deals are fairly typical like this, where a lot of times the sellers disclose all the needed information. They've worked with the broker, and the broker's identified a good prospective purchaser, and they want everything to move through quickly. As the attorney for the seller, I don't want that information being disclosed until we have a purchase agreement or an asset sale agreement signed. So we have stronger protections for confidentiality, and also we have some skin in the game from the buyer, or we have, let's say, a deposit. So again, it's not hard and fast, but you'll see different things. Now, I've had some software companies where they've actually, when they were going to sell their assets, they actually would have certain things that weren't revealed until the closing, because it was so confidential, and they were so concerned that if things fell apart before the closing, what do you mean falling apart, that the prospective purchaser wasn't able to get the financing to close. They didn't want that prospective purchaser to know about who their exact customers were, so that prospective purchaser could go after those customers. So we actually had it where we would describe the characteristics of the customers, and at the closing would verify, here's the list, and here are the characteristics. So this way they could proceed to close, but not reveal the information too soon. So again, you have different spectrums, and it depends upon the sensitivity of the information. And you have to make an assumption the deal may not close. So again, to consider how much to be disclosed, and a lot of it would be based on how demanding the purchaser is. You might not be able to get away with holding back certain information. But in most deals, at a certain point, everything's being disclosed, and that's usually during due diligence after a contract is signed. All right, so when does due diligence begin and end? Again, it depends on the deal. Sometimes due diligence is being done before any broker, before any attorneys involved. The buyer and the seller have been in contact. They've been introduced by whatever means, and they've just been, due diligence has been ongoing. Sometimes it's after a letter of intent is executed. It may be before an asset purchase or an asset sale agreement is executed. Again, no hard and fast rules. From the buyer side, the sooner due diligence begins, the better. And especially if it can happen before like a definitive purchase agreement is signed. From the seller's perspective, usually it's better if the due diligence, any kind of serious due diligence, doesn't occur until a definitive asset purchase agreement is signed. You have a deposit, and you have the protections in the agreement. So it's kind of like depending upon which side you're on, but definitely from the seller side, you want to make sure that the prospective purchaser is legitimate. They've taken the time to, and incurred the fees to negotiate a purchase agreement, and they paid a deposit. So that's ideally from the seller side. But again, buyer, they want it much sooner.
John, a question.
Yes.
Does due diligence ever, how often does due diligence end in a sale not happening? Is there a standard, do sales ever potentially fall down because due diligence just doesn't, pass muster?
Yeah, great question. I'd say it's a small percentage from what I've seen. I'd say it's probably around, taking a wild guess, 5 to 10%. And I'll tell you what typically happens is that if a buyer finds issues as part of due diligence, and let's say it's something that it fundamentally alters the understanding of the purchaser, whether it was something that was kind of hidden in the beginning, or once the prospective purchaser got in and started taking a look. I'll give you another pharmacy deal because it's on point. This prospective purchaser, very sophisticated purchaser at a bunch of other pharmacies. Once they started conducting the due diligence, they realized that the seller, they were about to start losing money based on the type of prescriptions that they filled. And I'll keep it very broad. And the seller wasn't even aware of it. But my client, again, so sophisticated, they knew the changes that were coming up, and they said, "Oh, based on this and based on the contracts that the seller has, we're not going to go through with the deal." I've had other cases where some bad things happened during due diligence. I've seen where tensions arose between the parties during due diligence, and but it's usually the exception. Usually, by the time you have a signed purchase agreement and the due diligence is being done, then I don't see it that often.
Money has been spent. People are, people are invested. Then is
exactly.
Yeah,
exactly. Okay. So also part of due diligence, the buyer's thinking, all right, what's needed to complete the purchase and operate the business? Are there any governmental approvals? If there's assignment of contracts, any other requirements? So these are things as a seller, you're going to think of, how is my business set up? How is it operating? So you can facilitate and answer these questions that you would have if you were looking to buy the business. All right, due diligence, just again, this is not a comprehensive checklist, just some ideas. There's many great checklists on the internet, but again, you're thinking this may be more from the buyer's perspective, but again, it could be from the seller depending upon the terms of the deal. But financial records, organizational paperwork, charts, customer, client, patient information, contracts, leases, et cetera, et cetera. So purchase price, valuation, and financing. So again, we're not going to get into the business aspects of it, but is a purchase price acceptable? And when I say acceptable, of course, obviously it has to be something the seller wants to live with. But in some cases, is there a valuation done? Do you really know the value of your business? Is a valuation required? In healthcare, there's a lot of cases where a transaction has to be at fair market value, and the only way you can really demonstrate that is by getting a valuation done. So there may be, you just considering, are there any type of obligations that require you to do a valuation? Are there multiple owners, and are all the owners in agreement? Does there need to be a valuation done to make sure that the sale price is appropriate? Will the purchase price be financed? Yeah, not from a business perspective, but this goes into the contract. Is it going to be from a lender? Now, a lender may not fund at the end of the day. The application for the loan may fall through, and all the things we're talking about, the due diligence is a consideration. This deal may not close. Is the seller going to finance the purchase? What are the terms that have to be negotiated and set forth in a promissory note? Now, typically, when you're a seller and you're going to take back a note, I hate it from the seller side. I love it from the buyer side, because you never know if you're ever going to see that money. The purchaser's business may fail, and now you may be left with just a claim to bear to the purchaser for what's owed. So you may never see it. You can try to secure that promissory note, maybe against the assets of the business. You could try to get a mortgage on the individual purchasers' homes. which would be hotly contested, but there's just a bunch of legal issues to consider. How do you best ensure you're going to get paid? Again, if you can avoid it, it's so much better. It's better to get the money and, at the closing versus getting it later. Now, again, the purchaser's looking from a different perspective.
John, just a quick question about valuations. Who might conduct an evaluation?
Yeah, there's special, there's companies that do the valuations. You have a lot of accounting firms do it. You have some very big companies that do it. And if anybody has a question, they can shoot me an email and I'll try to point you in a direction. Sometimes some of these financial advisors, there's some companies that they provide some of these valuations for like little cost because they're looking to develop a relationship, to help with investments and things like that. So, but some of the valuations can be pretty pricey because these things are complex. It's complex.
They are complex. And I think also if you're using a business broker, they might be able to help too, right?
That's right. It's funny because I've worked with some business brokers and they can, in certain businesses, they can tell you what the going rate is because they're doing so many deals. They basically know, all right, based on these types of contracts, this type of inventory, et cetera, it's worth X amount of dollars. And they're pretty good. And sometimes we've actually had certain agreements where we needed a valuation in the future, we would name a broker in particular.
Would the buyer and the seller have a valuation done, or would it just be one neutral party that would do the valuation?
Yeah, it depends, as always. Now, valuations, I'd say it's pretty much the exception for most of these deals. Usually, the seller, and the buyer, they work out the best price that they can. But again, if there's certain concerns, especially in healthcare, there's certain times where you can only have certain transactions at fair market value. And in that case, it's usually the acquiring party that'll do it, especially like if you have a hospital acquiring let's say a medical practice, usually the hospital has deeper pockets. They're usually a higher evaluation expert to do that. Okay, and then just not to go into a lot of details, but consider, are there any earnouts? So after the closing, does the seller, the owners get any type of compensation based on the productivity of the business after the closing? Are there any bonuses? Are there any commissions? And all those take very careful drafting. And that's what kind of touched upon what I said before about due diligence for a seller. If you're going to be kind of invested in the post-closing operations of the purchaser, you may be considering whether to do some more due diligence to make sure that all these things you're trying to negotiate are really potentially available, and not that the prospective purchaser is going to fall on their face. All right, so letters of intent. So letters of intent, we'll just quickly through this. So a lot of times in the beginnings of negotiations for the purchase and sale of a business, you have a letter of intent. There's key points that are often identified in the letter of intent. Purchase, price, whether it's asset or equity, earnouts, commissions, the types of assets, liabilities include, etc. So the key thing here is, one, it's not required. Not all deals have them. There's sometimes I like a letter of intent, sometimes I don't. Now, letters of intent are supposed to be non-binding, but I've actually seen some letters of intent that are binding. So you always have to be very, very careful in what you sign. Usually what will be binding in a letter of intent will only be a confidentiality provision. So, but again, it's something that has to be carefully reviewed to make sure you understand what you're signing. And I get people all the time say, well, I just signed a letter of intent that's not binding. And once in a while, it's actually binding. So the main terms are binding, and then the parties are meant to negotiate the rest of the terms. All right, so we go asset purchase or sale agreement. So I mentioned briefly before, typically a purchase of a small business will be a purchase of the assets of the business and not the equity of the business. The reason is that if you buy the equity in the entity that owns the business, so let's say it's Claire's LLC, and she has an ice cream shop. I like food analogies. So you have an ice cream shop. She's going to sell either the assets or the ownership. For a purchaser, it's better to buy the assets of the entity. And the assets could include the name of the ice cream store. Even though if your new company doesn't have that same name, you could do business as that name. The reason is the goal is to try to not have to basically take over all the past issues of Claire's LLC, to not pick up any type of liabilities that might exist. So that's what you're trying to do. You're trying to, as a buyer, to limit that. So as a seller, typically you don't really care unless there's ongoing obligations, which are not easy to terminate. So sometimes you may want an equity sale where you want to sell the, let's say, the membership interest of the LLC or the shares of stock in the corporation. Sometimes it may be easier, and there's sometimes tax advantages. So again, that's something outside this presentation you talk with your accountant, but most of the times it's going to be an asset purchase. And as a seller, it's not unreasonable I guess it would be unreasonable to try to demand a stock sale unless there's a really good reason. So to understand, that's a purchaser's perspective, and that's typically what's going to happen. So who prepares the agreement? Typically in New Jersey, it's the buyer's attorney. They want a lot more protections in the contract than typically the seller wants. It's okay for the seller's attorney to prepare it, but it's kind of more unusual. Sometimes there's brokers that have form agreements. I've never found them to be good for buyer or seller, so I'm always adding, revising the agreement. The worst is if the parties come up with something off the internet. That's just a disaster. All right, selected components of the asset purchase agreement, and we'll talk about these in a little more detail in the next slides. And these, a copy of the slides will be available after the presentation. So, identifying the sellers and the owners. Does the seller, again, we're talking about for an asset sale, this selling entity, does it have the authority to sell all the assets that are going to be sold? Are there multiple entities that have to be named as part of this transaction? Are there two companies that are at the same location, and do both companies have to be named as the sellers? Are all the owners of the selling entity going to be identified in the contract? From a buyer's perspective, I love it. I want the individual owners identified on that contract. As a seller, I don't want it. And the reason you want the owners from the buyer's perspective is that you want the buyers, the owners, you want the individual owners, those live bodies, to join in on that contract, join in on the representations and warranties, to join in on the indemnification, because the selling entity, at some certain point, it's going to be gone. And also, after it's no longer in business, all right, you go to sue that selling entity, it's just going to go bankrupt. There's not going to be anything there. That's why you want the individual owners when you're buying. When you're selling, you don't want to be on there. Now, you may not be able to do the deal without joining in those representations and the indemnification as the owner. So again, it depends upon the particular deal. So we talked about some of these things before. Again, you have to nail down the contract, all the terms of the payment, how it's going to be done, deposit, whether it's going to be financed by seller, lender, whatever. Is there going to be an earnout? Are there going to be commissions later? Whatever it may be. And sometimes there's escrows set aside for potential issues. Again, typically, and it can go both ways, but typically buyers will ask for an escrow to have some certainty that if things don't turn out a certain way that is anticipated based on either the purchaser's expectations, things that have been disclosed by the seller, etc., they may ask to set aside certain monies that if things don't turn out the way they were supposed to, that basically they can draw upon those monies. So it's part of the purchase price gets held back, not given to the seller, and may get held in this escrow, may get applied or given to the buyer. There may also be escrows in case there's an indemnification issue for a multitude of reasons. But again, as a seller, you're very concerned that once that escrow is established, you may have to fight to get that money, and it's just a pain in the neck. So from seller side, you don't want buyers holding escrows, but it may be the way to get to a deal. And again, each case is a little different. You have to think about the actual assets to be sold. And as a seller, as well as a buyer, you really want to identify what those assets are going to be in some detail. So there's no dispute. We talked before about the psychology of the parties. You want the goodwill of the other party as much as things, and it's amazing. People will misremember things that are said. They will misinterpret things that they've read. So you want to make sure that's very clear. So when as the buyer is going through the process, the seller and the buyer knows what's supposed to be delivered at the closing, and when the closing comes, there's no surprises. That's a terrible time to have someone say, "Wait, I thought such and such was supposed to be included." So again, you want to take away the chance of things really breaking down. You want to take away those surprises. I mentioned just quickly allocation of the purchase price. One of the things you need to make sure as a seller, and the buyer wants this too, is that the parties agreed how the allocation for the assets is going to be broken down. So everybody is filing the same type of allocation with the taxing authorities. You don't want the buyer to submit an allocation of the purchase price to the IRS that looks different from the seller, because now you have questions from the IRS, and that's not a good place to find yourself in. So it's basically, all right, out of this $1 million, maybe 150,000 is furniture, fixtures, and equipment. Maybe 800,000 is goodwill, and whatever the rest is, maybe for a restrictive covenant. Whatever it is, you want to make sure both parties are on the same page. All right. Typically excluded assets in small businesses will be, the cash that the selling entity has, their accounts receivables, the books and records, any contracts the buyer is not expressly assuming. There may be specific listed assets. Give an example. I had, I believe it was an Italian restaurant that had a lot of artwork on the walls, but there was one in particular that they wanted to make sure that they, at the closing, didn't go to the buyer. So things like that may be listed. And then anything else as appropriate. But you want to make sure that, again, there's no surprises at the closing. Everybody knows. And in this case, if we're doing an asset sale, these items are typically going to be excluded, but not always. There's some acquisitions, especially private equity, where they're looking for the cash in the bank accounts of the seller. They're looking for the accounts receivables. So again, it's not a hard and fast rule, but for a lot of small businesses, when there's no private equity involved as far as the purchaser, this is typically what arises. And again, we'd have to make sure that these are all addressed very clearly in the contract. Again, no surprises. So seller's liabilities. Usually a buyer does not want to assume any liabilities of a seller, but it's not always true. Some of the liabilities they may assume. They may take over the lease for the space. They may take over contracts, with customers. They may take over a lease for copy equipment. There's certain things they may want to assume, but the general rule is a buyer doesn't want to assume any liabilities. Again, this is something you want to make sure it's crystal clear, that if there's any type of ongoing obligation, you want to make sure as a seller that everything is nailed down in the agreement. Again, no surprises. Everybody understands what the deal is. And the more detail, the better. Okay, we talked about leases, contracts. There may be past conduct of the seller. There may be other liabilities. Again, each deal is a little bit different, but whatever the deal is supposed to be, to make sure it's very clear in the contract, what's being assumed by the buyer and what is not. So usually, once you have the purchase agreement, there's usually going to be some contingencies that have to be satisfied before the actual closing occurs. So selected contingencies. Usually, buyer and maybe seller has to be satisfied with their due diligence. The buyer may say, "Hey, we have to have our financing, and we're not going to close. Well, we don't get the loan from the bank. We're not going to go through." There may be certain governmental approvals that are needed: a CO, zoning, liquor license, other licenses. There may be third-party approvals. Bulk sales approval from New Jersey taxation, satisfactory litigation and lien searches. There may be guarantees, but just to understand what the contingencies are, because if these contingencies are not put in, then the parties have to go through with the deal. So you can, just a quick example, and you can see how this applies to any other contingency, is that if, as let's say a purchaser says, "All right, we need the loan from the bank or we can't close. Well, if that contingency is not in the contract, that's not a contingency. And they still have to close even if they don't get the loan. Of course, they won't be able to fund it, but then it's, potential litigation. So from the seller's perspective, anything that needs to happen before the closing occurs, which may be a post-closing employment agreement with one or more of the owners. It may be certain type of agreement for earnouts, whatever it may be, to make sure that those things have to be done before the closing occurs and to make sure it's clearly set forth in writing. All right, we have selected representations, warranties. Typically, purchaser is going to be doing their due diligence. They're going to be checking what they can check, but they can't check everything. They can't verify everything. So they're going to be asking for a bunch of representations and warranties from the seller. And as I mentioned, they're going to want the owners, the live bodies, to join in those representations. Certain representations may cover some things that they can verify. But there may be certain things that they can't verify. So for example, maybe they can verify that the seller is in good standing. The corporation is appropriately formed. It's in good standing. It hasn't, their status hasn't been revoked, but there's some other things that they might not be able to verify. The purchaser might be able to check them to see if there's any litigation filed against the seller, but they can't know if the seller received a phone call that they're about to get sued. So they want all these representations to be made to get protection. Seller wants representations from the purchaser as well. But typically it's not as extensive. But again, going back to what I was saying before, the more invested a seller is in the operation of the purchasing entity after the closing, the more representations and warranties they may want. So again, just some examples. It's not an exhaustive list, and you'll have a copy of the slides if you'd like those. Some selected representations and warranties of a buyer, just that the buyer has full authority, they have adequate funds, and then other contingencies depending upon the circumstances. All right. You also typically have in these agreements, covenants before and after the closing. So the buyer wants to make sure that the business is going to be conducted in its normal course. Now, the seller may have an interest in the way the business is going to be conducted after the closing. Again, if there's any types of escrows that are being held for certain reasons, if there's earnouts, if there's commissions, there may be execution of contracts before or after the closing that have to occur, performance of any duties. So again, depending upon the seller's, what the seller needs to happen either before or after the closing, there may be certain things. Again, everything that's material needs to be named in the contract. So we get to indemnification and considerations. So both sides are typically looking, and a lot of times in these small businesses, the buyer's more interested. I mean, they're both interested. The buyer has more of a concern because they're taking over an ongoing business. Seller has concerns too. But typically what you want is indemnification. If it's going to be mutual, both sides who agree to say, all right, if anything happens based on our breach of the agreement, if we lied, we breached any of our representations and warranties, and that's another reason why those representations and warranties are so critical, or there's any claims against us, that we will defend, indemnify, and hold you, the other party, harmless. So the buyer wants the seller to say, all right, if something happened before the closing with the business, that should be the seller's problem. It shouldn't be ours. And seller, you should step in and take care of fighting it, take care of defending the legal action, pay any types of monies that might have to be owed. The seller wants the same thing from the buyer. After the closing is over, they don't want to worry about what happens after the closing. They want the buyer to be responsible. And this goes back again when I mentioned about the owners. The buyer wants those owners on the hook if something happened before the closing, because again, after the closing is over, at a certain point, that selling entity is going to be dissolved, or at least it won't have any money really to pay for any significant issues.
And John, that goes to a question that we had, which is when you talk about the monies in escrow, which is what they're there for a certain. Yes. The question was, who controls the monies in escrow?
Great question. I'll say it this way: you always want your attorney to control it. Sometimes more sophisticated deals, especially with private equity, is a purchaser, they will insist on a third-party escrow agent, a big bank, and the escrow agreements are very lengthy. It gets very expensive. But I would say for a small business, the general, I guess the general rule of thumb would be the attorney for the party that would benefit from the escrow should be the one holding it. And that's how I'd say it to make it fair. So if I'm representing the purchaser and there's an escrow for indemnification for issues that may have occurred before the closing and may be responsibility of the seller, I'd want, as the buyer, I'd want my attorney to hold it, and vice versa. If there's some performance item and there may be a payment to the seller after the closing and there's an escrow for it, as a seller, I want my attorney to hold it.
Okay, thank you.
Oh, my pleasure. Okay, we'll talk quickly about restrictive covenants. So restrictive covenants, non-competes. Now, it's never clear what's going to be enforced. There's a lot of push. You've probably seen on a national level. There's concern about restrictive covenants. The concern is that it really harms people from earning a living. It's not so much a concern when it comes to selling a business, but you can imagine a purchaser is going to, and I know of a case, it was a bagel shop down in South Jersey. It was a purchaser of a bagel shop. They bought the assets. There was of the bagel shop. There was no restrictive covenant for the seller or the owners. Again, we get back to the owners issue. The owners opened up a half a mile down the road under a different name within like 6 months, and they took a lot of the business away. So, and they didn't do it by soliciting the customers. They just opened up another business, and everybody say, "Oh, so and so is down the street. Let's go back. We love this person." So, restrictive covenants are critical and become very detailed depending upon the type of business, what you're looking for, but they have to be reasonable. So if, different areas, I give, an example, again, a pharmacy deal, because, a good example for this matter. I was working with attorneys from another law firm, same law firm. In one case, I was on the seller side, in one case, I was on the buyer side, two different pharmacy deals. One was up in one of the cities in, northern New Jersey. And one of the pharmacies was down in, it was like, I don't know if it was Cape May County or whatever the county is where Vineland, New Jersey is. And in Vineland, New Jersey, the restrictive covenant, the non-compete was, I think was 15 miles for so many years after the closing, that the selling entity and the owners would not open up another pharmacy. Up in the city, we put in a number of blocks, because really it was how far will people travel to get these services. So each deal has different, I guess, needs for a restrictive covenant, and you're always thinking as the attorney, how can I do this where it's hopefully going to be enforceable and not piggish? Where if, let's say, I'm representing a purchaser of a pizzeria, and I ask that the restrictive covenant is that the owners never open another pizzeria for 50 miles. That's probably insane, because most people don't drive that far for pizza, unless it's really good pizza. But so that would probably be unenforceable. But now 50 miles for some other businesses might make sense. 50 miles maybe for a certain type of surgeon might make sense. I don't know. But just to understand, there's different criteria, and you want to make sure that's going to be reasonable. And then you also want non-solicitation. The buyer wants non-solicitation of customers. They don't want the seller going after their employees. And again, so these are critical things to understand the buyer wants. But depending upon what's going on with the post-closing, the seller may want this. The seller may have affiliated entities in other locations where they don't want the buyer now going after their employees, after their customers. So again, these things become very involved, and depends upon the particular matter. All right, there's always additional provisions depending upon the business that might be in an agreement, whether there's a liquor license, whether there's a Department of Health license, pharmacy provisions. Maybe there's services of the owners before or after the closing. Maybe there's certain things that have to be addressed as far as transitional period before and after the closing. Again, it depends upon the nuances of the business itself. Now, I'll talk quickly about equity purchases because we're almost out of time. I mentioned quickly before, typically you don't want to, as a purchaser, you usually don't want an equity purchase, but sometimes it makes sense. Again, it may be too complicated to just buy the assets, maybe because of the nature of the contracts. that the seller holds. Making an equity purchase makes more sense. Maybe somebody works in the business and they feel comfortable. Maybe it makes more sense for an equity purchase. Again, each case is fact sensitive, but it does come up, but it's probably the exception rather than the rule. So the equity purchases, again, different from the asset purchase. There's similar concepts from what we've been discussing, but you're talking about the ownership in the entity that holds the asset. So I always like to tell people, consider like two deals. You're acquiring the ownership interest, the equity, but you also want to make sure that all the things we talked about, identifying assets, the liabilities, all the contracts, et cetera, still have to apply for that contract. But you're also bringing in the issue of the actual ownership, and then whether there's any liens, judgments, et cetera, against the ownership, in addition to the individual assets. Again, very superficial discussion. We could talk about this for hours, but just think about that general concept. And then we get to the closing. So at the closing, ownership is transferred, a title to the assets is transferred, or to the equity if that's what's being purchased. Purchase price is paid, and maybe that's in the form of a promissory note. Maybe it's paid cash. All the closing documents are executed, and then all post closing actions are taken, whether it's tax filings, license notifications, etc. Some selected closing documents. Again, you can get a copy of these slides, and definitely not an exhaustive list. There's resolutions of the companies. There's a closing statement showing what's actually being purchased, the amount paid, bill of sale for any assets. There may be leases that are needed, assignments of intellectual property, non-compete agreements, employment agreements, and any other documents that are necessary to complete the closing for that matter. And then just post-closing, again, there may be different issues that may have to be taken care of after the closing that need to be identified in the purchase agreement, whether it's liabilities assumed, governmental filings, approvals from third parties. Again, all these things need to be fully explained in the agreement. So again, you don't want any disagreements even after the closing. All right, and that's the end of the slides. And I don't know if there's any other questions. And I'm happy if someone wants to shoot me an email, I will get back to you. And if you have any questions. So, and that's a standing offer.
Thank you, John. That's really nice. There is another question, which is, this is a great question. As a seller, I'm talking to an out-of-state buyer. Which state is the contract state?
Oh, fantastic. If I had a softball question, that would have been one of them. Which contract should it be? Yeah,
which state should it be contracted in?
Yeah, you as a seller, you want it for your state. Again, this depends upon negotiation. A buyer is going to want their state, and I'll tell you a couple of reasons. One is, if it's your state, there's a little more certainty. I mean, you've been operating in your state. There becomes some subtleties of another state and the application of law to the sale. It can get a little bit complex. But with that, you want your home state to apply. Also, you want the venue, to the extent you can get it, is the venue to be for any disputes that arise, that you're in your county court house, and you're not out in the purchaser's jurisdiction. So you think of them together. One is the application law. Again, definitely as a seller, you want it typically. Again, there's once in a while there's exceptions, but typically you want your home state, and you want the venue for any disputes to be, the county that's either where your business is, or maybe sometimes your attorneys are, where it's just better for them to go to that court. So yeah, that's an important issue.
There's another question here, which is, let's say you're doing an asset purchase. The seller has contracts that can't be assigned without the other party's approval. Yeah. How do you get around this? I actually experienced that when I was selling my business. It's fun.
Yeah, it's interesting. And it's one of the reasons sometimes I think, oh boy, I'd love to do this for like 8 hours because there's so many details going on. And I feel terrible because I have to brush over some of these. Great question. Now, that may be a reason why an equity purchase may make more sense than an asset purchase, but it depends upon the assignment provision. Sometimes in those contracts, it may provide that the contract can only be assigned with the approval of that other party. Sometimes they will say an assignment would deem to have occurred if there was a change in ownership, maybe 50% or more. So even an acquisition of the equity where you acquire the ownership in that entity that has those contracts, it still may be deemed an assignment for which you need approval. So having said that, there's always, again, it gets part of a dance. As a seller, you don't fully know if this deal is going to go through. So you may not want to even ask for those assignments until you're really close to closing. The buyer may say, I'm not going through the deal unless I get those contracts. I've seen in one of the deals in particular, it was a certain special services company. They basically approached some of the customers that they thought would be okay right before the closing. But what the purchaser did is they held back a pretty significant escrow and saying that there's certain benchmarks. If these if certain percentages don't, agree to assign to the purchaser, then the monies would be, given back to the purchaser, would never go to the seller. Usually in those cases too, the parties kind of agree to cooperate after the closing to facilitate the assignment. But it's a thing that causes a lot of stress right around the closing.
And one thing one piece of advice I always offer to small businesses now is always think when you're signing with buying and selling of your business, but well, it is, but it's when you're in the present and you're negotiating contracts with customers, employees, suppliers, think about the long term, because I know as a small business owner in the beginning, when I very first started my business, I would, we'd get a contract from someone and we'd just sign it. We wouldn't even look through it. We'd be like, oh, look at all that legalese. I'm sure it's fine. The customer wants to give me money. I'm going to take it and just, and sign away. And then when you go to sell your business, there's a lot of things in there. So always think about the big picture of contracts and agreements when you're going through them, because even though things that might seem insignificant at the time, think about your long-term goal for your business. What is your long-term goal? Because if you think at any point your business is going to be sold, consider that when signing contracts now. That's learned the hard way.
Absolutely. And that's a great point. I'll give a flying analogy. If you're going to, get in the cockpit and take off for a flight, you've already thought about where you're going to land, and you've thought everything through to make sure it's going to be a safe flight and you're going to have a safe landing, etc. So going to Claire's point is to really think about, at some point, you're not going to be, as an individual, you're going to either sell, you're going to, whether it's the assets of the entity, maybe some, going to bring in other owners, whatever. At some point, you're not going to have the company anymore. So you think about how do you facilitate that transition now? And again, to what Claire said, not thinking about that can make it much more complicated down the road.
I've just realized the time as well. So I think we have to wrap up. There is one question
Sure.
about how to reach out to you, John. Can you just give your email address out?
Absolutely. And it's going to be, let's see. Let me see if I'm going to show it on the screen. And then of course you can request a copy of the slides, but yeah, best way is to get me is to send me an email. Some reason I don't respond. Once in a while, I have two. I found out I have two spam filters. I never even knew it. So for some reason it doesn't come through. Just then call me, and that's my cell phone up there, and it's fine for you to reach out. Not today's a bad day. I'm actually going to court for a matter, so I won't be around for the rest of the day. But definitely reach out. And again, if you don't hear from me within a day, just reach out again and then try a call. But I'm pretty good.
I can attest to that. John is very good at getting back to you. So, all right. Thank you, John, so much. I am kind of disappointed that this series of webinars is over, because they've been really, really informative and really great. So just a reminder to everybody, they are on our YouTube channel, so you can refer back to them. We can, as John said, you have his contact information, and you can ask him questions as well. And of course, always, if you have any questions about your business, you can reach out to us at SCORE. That's what we do. We help. We have a bunch of retired executives and still working executives, but we have a bunch of executives with a host of and wealth of information that can help you. So we will see everyone on the next webinar. They're all listed on our Facebook page, our LinkedIn page, our website. So look forward to seeing you on the next one. John, again, thank you so much. Really, really appreciate it.
Thank you. It's an incredible honor, and I really mean that.
Thanks, John. We'll see you.
All right.
Bye,
Take care, everybody.
Bye, everyone.